Now, on the final day of judgment in the matter of the 2020 election petition, we've seen the likes of the petitioner himself, John Dramani Mahama, his running mate in the 2020 general elections, Professor Nana Jane Opoku-Agyeman. We've also seen the chairman of the NDC as well as the general secretary, Johnson Asiedu Nketia, who happens to be the star witness in this petition, all here at the Supreme Court. We've seen increased security presence, and all this goes to tell you the importance of this judgment or this final verdict pronounced by the justices, the 7 justices sitting on the 2020 election petition. Well, judgment has been pronounced. The election petition filed by John Dramani Mahama has been dismissed as lacking merit. What are the details? My colleague, Sixtus Don Ulo, sat in court and brings us the details in this report.
Chief Justice Anini Yeboah, together with Justices Iyawa Pao, Mafo Sao, Nene Amegache, Ashikote, Tokono, and Ousu, were unanimous in dismissing former President John Mahama's petition challenging the outcome of the December 2020 presidential election. The case traveled 65 days from December 30 when it was filed, with 50 effective court sitting days since its first hearing on January 14. And contrary to preliminary arguments raised by President Akufo-Addo's lawyers for a summary dismissal of the petition, the court found that Mr. Mahama's petition raised reasonable cause of action and had to be heard in its full course.
We are convinced that the petition discloses a reasonable course of action. We wish to state that a court called upon to decide whether or not a party has a course of action must not dwell so much on the strength of that party's case, since that can only be determined if the matter is submitted to trial. For example, in this petition, the court must assume jurisdiction in order to determine whether the averments regarding the declaration of results and the issue of CI 135 are sustainable in law, whether there was vote pardon, and if so, whether it had any impact on the results declared by the chairperson of the first respondent. On this issue, therefore, the argument that the petitioner must have a weak case On this issue, therefore, the argument that the petitioner may have a weak case is no good ground to summarily dismiss the petition as contended by the respondent.
For the court, out of the 3 witnesses former President Mahama presented to aid his petition, only Johnson Asiedu Nketia's testimony was reliable. The testimonies of Rojo Metal Nunu and Dr. Kwesa White were described by the court as fanciful.
Out of these 3 witnesses, the one whose testimony appeared to have some relevance to the issues at stake was Mr. Johnson Asiedu Nketia, PW1. He was, in fact, the star witness of the petitioner. His testimony vividly explained the reasons why the petitioner is in court. As for the other 2 witnesses, that is PW2 and 3, Dr. Kwesa White and Mr. Robert Joseph Metinunu, the little said about their testimonies relative to the issue at stake, the better.
According to the judgment, Mr. Metinunu and Dr. Kwesa White can only blame themselves for abandoning their duty post of trust as assigned them by the petitioner.
Their testimonies were therefore of no relevance whatsoever to the issues set down for determination, and we found them unworthy for any consideration whatsoever in the settlement of the issues. In fact, regarding the testimonies of PW2 and PW3, if their evidence is to be believed, then they have to blame themselves for abandoning their post at the National Collation Center at the time the verification and certification of the results were ongoing.
On the thorny concern of the Electoral Commission surreptitiously rectifying its errors without recourse to the stakeholders, the law lords held that this could not be dramatized.
What is the legal implication, if any, of first respondent failure to involve the petitioner and his agents in correcting administrative or clerical errors made in the computation or the declaration? Neither the petitioner nor his witnesses mentioned any to us, and we do not find any.
On the question of whether or not Nana Addo Dankwa Akufo-Addo of the NPP obtained the constitutional threshold for declaration as president, the Supreme Court held
There is no doubt that the petitioner accepts that the total valid vote cast was 13,121,111 and not the figure 30,434,574 erroneously described by the chairperson of first respondent on the 9th December 2020. Having determined on the evidence adduced at the trial that the total valid votes cast was 13,121,111, there is no legal basis for anyone to contend that a different figure of 30,434,574 be used as the total valid votes cast in measuring the more than 50% threshold required under Article 63, Clause 3 of the 1992 Constitution. We hold that there is evidence on record to show that based on the data contained in the declaration of the chairperson of the first respondent, the second respondent obtained more than 50% of the valid votes cast as required by Article 63, Clause 3 of the 1992 Constitution.
And could the presidential results of Techiman South have tilted the scales against Nana Akufo-Addo?
It has been established without any dispute whatsoever that the national total valid votes cast without the votes from Techiman South was 30,121,111. So adding the total valid votes from Techiman South will give a national valid votes cast as 13,220,547. That's into bracket 13,121,111 plus 99,436,000. From the calculations above, the second respondent nonetheless made the more than 50% threshold required under Clause 3 of Article 63 of the 1992 Constitution.
The court also held that it did not find any evidence of vote padding or in proportions significant enough to have otherwise impacted the outcome of the 2020 presidential poll. On the strength of the aforementioned holdings, Chief Justice Enin Yeboah said the court was unable to order a rerun of the presidential election between President Akufo-Addo and former President John Dramani Mahama, as had been prayed.
Petitioner did not demonstrate in any way how the alleged errors and unilateral corrections made by the first respondent affected the validity of the declaration made by the chairperson of the first respondent on the 9th December 2020, as already stated in this judgment. The petitioner has not produced any evidence to rebut the presumption created by the publication of CI 135, for which his action must fail. We have therefore no reason to order a rerun as prayed by the petitioner as in relief F. We accordingly dismiss the petition as having no merit.
As the court pleases.
The Supreme Court has dismissed the election petition, the 2020 election petition, as lacking merit. And as you can see, the various parties, i.e. the petitioner, the first respondent and second respondents, together with their legal teams, are making their way out of the court. Generally, you can see Mr. Mahama in short. You can see General Secretary of the NDC, Johnson Assedu Nketia, who was the petitioner's witness number one. Well, generally, you can say that it's one of a dull mood, purely one of dissatisfaction. You can see the various individuals forcing to put up some smiles, but obviously they have lost an election petition case at the Supreme Court, and so you can tell that there's some feeling of dissatisfaction amongst them. You can see the petitioner, former President John Dramani Mahama, going to his vehicle now. Then we see other dignitaries, other members or high-ranking members of the NDC still around. Generally, the case has ended. Court has dismissed the petition, and so not much activity out here except for the departure of the various parties involved. A very jubilant NPP side. We can see them waving their white handkerchiefs already, obviously, in celebration of victory, if you like it, having been declared winners or coming out of the court victors in this particular petition. And so we can hear some singing, some chanting, and the waving of white handkerchiefs in the air, obviously to signal their victory in the 2020 election petition case. We can see the likes of lawyer Frank Davis. We can see Godfred Dame. We can see Nana B in there. We can hear them singing to the glory of God, obviously, in celebration of the dismissal of the petition as was brought by former President John Dramani Mahama.
The Lord Justices of the Supreme Court have spoken. We entreat all Ghanaians to abide by the decision of our highest court of the land. We thank our good friends on the other side for their bravery in mounting this petition, albeit we all found that the petition indeed contained nothing but factual errors and inaccuracies. Those were in the words of the court, not mine. Litigation must always come to an end. We want to believe that this is the end of the 2020 election petition.
Chairman, you are labeled as the star witness, but you never got to mount the box. Do you still carry the star?
Well, it's the legal process and the court processes and the nature of our court systems. It's adversarial, and I'm not supposed to assist or help my opponent to bring up his case. He called his 3 witnesses, and thereafter I said, hey, my statement is no more needed and is allowed in the court of law, and that's exactly what happened. So we are happy that
you represented President Akufo-Addo in court. Now,
very well, sir.
Right from the onset, your team dismissed the case as an incompetent one, an incompetent petition. But today, the verdict established that indeed there was reasonable cause for action. Does this not play into what the NDC has been saying all throughout, that there was a deliberate attempt to discredit their petition?
Oh, come on. You bring a case to court, all the reliefs you sought have been dismissed. What else do you want? That's no case. The case has been dismissed outright, 7-0. And we are happy, we are elated about that. So I don't think that the immediate course of action dismissal berates us. No, we've done the right thing. We've put up a good defense as demanded by the law courts, as demanded by facts, as demanded by data. You see, we went into the courtroom with data, facts, and law. So these 3 essential ingredients was what we brought to court.
As campaign manager of the NPP, we've seen 2 election petitions in the history of Ghana. What does this particular verdict say going forward with respect to our election?
I think it deepens our election is a major component of our democracy. So it deepens our democracy Africa-wide and worldwide. And I'm happy that other countries have been watching what's been going on. And today I've had messages from Uganda, etc., who have been watching on daily basis the proceedings, and they're happy about the outcome. And I'm also very elated and happy about the outcome.
Thank you very much. You heard the campaign manager of the NPP in the 2020 general elections.